You know, we talk a lot about our rights and freedoms here in Canada, but have you ever really stopped to think about what's holding it all together? What are the actual laws that protect you? Well, today we're going to break it all down, from the massive ideas that shape the country to the specific rules that affect your day-to-day life. Let's jump in. So here's our roadmap. First, we'll get clear on the difference between human rights and civil rights. Then we'll take a quick trip back in time to see Canada's first steps. After that, we'll get into the superstar of the story, the Charter. Then we'll see how this all applies to you at work and at home. And finally, we'll talk about the limits of freedom.
Okay, so let's start with a question for you. You hear these terms, human rights, civil rights, thrown around all the time, right? But do you actually know the difference? Nailing this down is pretty much the key to understanding everything else we're going to talk about.
So yeah, let's start right there, with the absolute basics. Getting the distinction between human rights and civil rights is so important, because it really explains how these protections get written into our laws and, how they're actually enforced. The easiest way to think about it is like this. Human rights are the big, universal idea. They're the freedoms that everyone should have, just because they're human, period. Civil rights, on the other hand, are how a specific country, like Canada, takes that big idea and makes it real, with actual, concrete laws. So one is the universal principle, the other is the legal guarantee you have right here. So, how did Canada end up with the system we have today? Well, it definitely didn't happen overnight. It's really a story that's been unfolding for centuries, and it was shaped by some major turning points in world history. You could say our story starts way back in 1215 with the Magna Carta. That's where we first get this incredible idea that nobody, not even the king, is above the law. Now, let's jump forward a few hundred years to 1948. Right after World War II, the UN creates the Universal Declaration of Human Rights, which sets this new global standard. And that was the inspiration for Canada to create our very first Bill of Rights in 1960.
But, and this is a really big but, that 1960 Bill of Rights had a huge weakness. It was just a regular old law. That means Parliament could change it, or even get rid of it whenever they wanted. Plus, it only applied to federal stuff, not the provinces. So it was a nice idea, but it didn't have much teeth.
And that brings us to the main event, the real game changer. In 1982, everything shifted. Canada brought home its constitution, and baked right into it was the Canadian Charter of Rights and Freedoms. This wasn't just another law, it was the new bedrock for all our rights. The magic word here is entrenched. What does that mean? It means the Charter is part of the Constitution itself, which makes it the supreme law of the land. Any other law that clashes with the Charter can be struck down by the courts. And changing it, it's incredibly difficult. That's where its real power comes from. So what exactly does the Charter protect? Well, right at its heart, in Section 2, are what we call the fundamental freedoms. The freedom to believe what you want, to say what you believe, to gather peacefully with others, and to associate with whomever you choose. These are literally the pillars of a free and democratic society. Okay, so the Charter is this huge national standard, but how does that affect you when you're just, trying to rent an apartment or get a job? That's where provincial laws, or human rights codes, come in. They take those big principles and apply them to our daily lives. We're going to use the Ontario Human Rights Code as our example.
The Ontario Code is really specific. It focuses on protecting you from discrimination in 5 key areas of your life.
And here they are. These are the big ones where fairness is legally required. Your job, where you live, the services and stores you use, any contracts you sign, and if you're in a union. Basically, it makes sure you get a fair shake when you're out in the world doing everyday things. So what kind of unfair treatment are we talking about? Well, the code lists 16 specific grounds for discrimination that are prohibited. This includes things like your race, your sex, your gender identity, if you have a disability, or your religion. You can't be treated worse in those 5 areas because of any of these protected parts of who you are. Okay, this leads us to a really important and kind of tricky point. Are our rights absolute? Can we do anything we want in the name of freedom? Here in Canada, the answer is actually no. Our rights are always part of a delicate balancing act with the needs of everyone else in society.
Think about it. Does your freedom of expression mean you can say literally anything, even if it's incredibly harmful to others? Well, from a legal standpoint, that's a clear no. And there's a reason for that.
The Charter has 2 major safety valves built right in. The first is Section 1, the Reasonable Limits Clause. This lets the courts decide if a law that limits a right is actually justified in a free and democratic society. Then you've got Section 33, the super controversial notwithstanding clause, which lets a government just say, this law is going to operate notwithstanding certain charter rights for up to 5 years.
A perfect example of reasonable limits in action is the famous Keegstra case. A teacher was charged under hate speech laws. He argued it violated his freedom of expression. But the Supreme Court said, nope. They ruled that laws against promoting hatred are a reasonable limit on free speech because the harm they prevent outweighs the limit on the individual's right. It's that balancing act.
And that brings us to our final massive question, the one that politicians and lawyers are still debating today, the notwithstanding clause. Is it a crucial tool for democracy, allowing our elected governments to have the final word on important issues, or is it a dangerous loophole that gives politicians the power to just ignore our most fundamental rights? That tension is right at the heart of Canadian human rights law, and it's a debate that is far from over.